SJC 13380, Norvella, Hill-Junious, the UTP Realty, LLC.
Attorney Hanson, whenever you're ready.
Chief Justice Budd, Your Honors, if it may please the court, I am Attorney Matthew Hanson. I represent the appellate plaintiff Norvella Hill-Junious and the estate of Drake Scott. In this negligent security case, Norvella Hill-Junious, the appellate, alleges that the defendant property owner was negligent for failing to provide reasonable security measures that would prevent and deter against foreseeable crime. The crime, in this case, a murder, was foreseeable because, like the violence and the gun crimes that happened before it, it happened outside a tenant's nightclub in the wee hours of the morning, outside of a live music event where people were accumulating around the parking lot. This is a series of circumstances. Many people in this case, many parties, including the Randolph Police Department, agreed was a recipe for violence.
What's the rule that we should have? When should owner of a piece of property that has a club in it know that there's danger and they need to take special precautions?
Sure, well, and of course I think that's what brings us here, because many of the cases that came before it dealt with residential apartments, commercial properties where there were no prior crimes. And I think the answer to that question, dare I say it, and I know we're here to address mostly the question of duty, but when you get sort of down the rung of questions, so duty, foreseeability, and all these elements, eventually you get to a point of what's the use of the property? A property owner buying a 10-year-old property is not going to check for asbestos, nor should they have to. But if they're buying a property that's 75 years old, they very well may have to, especially if there's insulation and there's powder coming from it. If the use of the property is to have something that has a heightened propensity for violent crime, like a nightclub, this is not normal. Most commercial properties don't have a nightclub with live music.
Are you arguing that creates a special relationship?
I don't know that I'd say it does follow the same track, sort of with Pine Mullins and the Fund v. Hotel Lenox case, where they addressed the relationship between a person at a hotel or a college student.
A landlord who doesn't run a nightclub but rents to someone who runs a nightclub has a special relationship to the nightclub's patrons?
Well, yes, but I believe the circumstances here are slightly different because the person was harmed in the common areas of the property. And I think that's important because if they were hurt inside of the bar, we would not be suggesting to you that the owner of the property has any right to go inside the bar and do anything. And I think that's been addressed in previous cases. This panel, I believe, addressed it in the Heath case in 2021. I don't believe that's in the briefs of the record appendix, but I do understand that was an issue where the property owner had no right to the property because they were listing it through an Airbnb. So if it happens inside of the club, no. The landlord or the property...
I don't think that was the reasoning of Heath Lanson. I think it was that there was no duty. There was no duty in that situation to protect an individual from a third person, and that it wasn't foreseeable. And here you have, I think, steps from the nightclub, a clear retaliatory shooting that has nothing to do with what's going on in the nightclub. It has nothing to do with the open mic. It has to do with a family member had been allegedly killed by the decedent previously. So it's nothing about the danger of the nightclub, and duty is an issue of law. And I think that Heath Lanson versus Styler is really not a helpful case for you.
I would disagree respectfully because if my memory serves me correctly, one of the issues that were addressed in Heath, as well as I think Griffiths and Whitaker and most of the cases cited in the briefs, when you get to the question of duty, you're looking at whether there were prior crimes. And I don't believe there was similar prior crimes, other shootings, murders, things like that in Heath, and I would submit not in Whitaker, not in Griffiths, and many of the cases
Weren't
cited.
there gaps in security I mean, like the hotel case, I vaguely remember, I mean, people are being attacked in this hotel through the same sort of negligent security. Don't we focus on the fact that the connection between the negligence that's identifiable and the injury here? This could have happened anywhere. These guys could have met on the street. They could have met at a restaurant. They could have met, at a traffic light. There's nothing about the nightclub except for the fact that they came there together accidentally. It just seems different from these other cases.
It may be different if we look at this as a targeted killing. I know that it was a premeditated crime, at least from the prosecutorial standpoint. But a lot of these crimes, the Sharp versus Peter Pan bus case,
But it wasn't, there was nothing about what the nightclub, again, the hotel doesn't have its doors locked, so this guy comes in and rapes somebody. That's not going on here. The fact that it's a nightclub and they did an open mic has nothing to do with why this person was shot, as Justice Lowy just pointed out. There's no connection between the two.
Well, I would disagree. This is a negligent security case, so of course we're talking about security. And the Randolph police, as well as I believe our expert and other people have said, security deters crime. Now this gentleman, Gregory Wright, the murderer, he ran. He tried to get away. The Sharp versus Peter Pan bus case tells us security, detailed uniformed security officers do deter crime. Now,
So if the duty is to have armed security and Jeeps roaming every parking lot, that's easy, right? It's going to deter crime. The question is whether or not, A, there's no special relationship, and B, whether it's foreseeable if there's no special relationship. And we have here one incident of a guy getting conked on the head with a beer bottle. That's it.
If I may address...
On her watch, essentially.
Sure, and if I may address that. On that issue, let's remember that the Randolph police went to that incident. It's essentially a brawl outside the nightclub, or it develops into a brawl outside the nightclub. Police from neighboring departments come due to the sheer number of people. So when we talk about what could happen, yes, somebody was stabbed or hit with a beer bottle. This is something that requires police from all districts to come. That's how big of a deal this is. I just want to touch upon, though, the security issue and whether or not this is going to deter crime. I don't think we can look at this as something that can be disposed of on summary judgment, because we don't believe the security officer or detailed security officer would prevent crime.
Well, isn't duty a legal question?
Right. If we go back to that, if we're going back to duty, I would say
You know the answer to that, so it's amenable to summary judgment.
there are prior duty is a question for summary judgment, of course, question of law. I would submit to you this. There is a question of duty in negligent security cases. Duty is contingent upon foreseeability. That's how we get here. Here there were prior crimes. The question, and I believe this is what the court took sua sponte, was whether the property owner has a duty of inquiry beyond just, were there prior crimes? Because ultimately what we're saying here is there were prior crimes. There was another shooting. There was more violence. There was gun crimes that didn't involve shooting of people, but people were firing guns off in the parking lot. This is not normal behavior. This is not something that somebody can just ignore.
What about the amicus point? So we're going to impose some sort of duty of landlords when they purchase to go and check for X amount of years about the crime. What's that going to do to the ability to get loans, the cost of insurance,
Sure.
the value of property? What are the implications, as the amicus brief points out, for the folks living there?
Sure, and to address that, 2 points. First, we're not suggesting that there should be a general rule that all property owners, somebody buying a single-family home and Airbnb being it, that should not be the general rule here. We're specifically asking that the use of the property come into play. When you're buying a commercial property with a dangerous nightclub, at that point, yes, you should ask the question. But more directly to your point about the amicus briefs, and I try to be very measured in my response. I do a lot of plaintiffs' negligent security work. The vast majority of victims, the people who have lost their loved ones, the people who are hurt, are people of color and people from marginalized communities. The briefs say nothing about that. But if we're going to talk about these things that are outside of the context of the law, duty, foreseeability, then I would ask that we at least speak the truth about them in context. So to Justice Lowy's point about mortgages and insurance, who bears the burden of these cases? Of course, it's insurance companies. Now, which first-generation immigrants, which I know is cited in one of the amicus briefs, where's their burden? To be frank, if they're so wealthy that they can buy multi-million-dollar commercial properties without a mortgage or a bank to escrow liability insurance payments, then yes, if they're that rich, they may be left with a judgment to pay. But whether they're a middle-class white person from Nebraska, whether they're a first-generation immigrant or they're a person of color, regardless of the case, most people buy property with liability insurance.
I think the policy issues are really complicated and over our head, but I mean, we say in these cases that we don't impose liability for the criminal acts of third parties except in exceptional circumstances, right?
True, yes.
Is this really what we're talking about here? Is this really an exceptional circumstance, or is this going to be, anytime you run a restaurant in a high-crime neighborhood or a nightclub in a high-crime neighborhood? I mean, what are we talking about here? I mean,
I think why we're here is why it's so rare. Most of the cases involve either residential apartment complexes where there are no prior crimes, or they involve commercial property like a hotel or a college campus where the case was allowed past summary judgment. Very rarely do I think you're going to find a property owner say, you know what, I keep having shootings and crime and violence on my property, but what am I going to do? I'm only the owner. I don't think you're going to see that very often because there aren't that many commercial properties with nightclubs that are inviting crime.
I thought the interesting part of your argument, one of them was that she had worked or owned the nail salon in the adjoining property, so she had to have known.
Well, yes, and that was sort of originally why we appealed the case. Of course, the question changed a little bit when the court took it sua sponte, but yeah, originally what we're saying here is, look, there's foreseeability. If we're just going by duty and then duty hinges upon foreseeability, it's there because there's prior crimes. Now, she says...
It predates her 3-month ownership, but you get the problem of her in the deposition saying, I didn't know anything about this.
She says, I don't know. And so the veracity of her statements are taken as true. We offered affirmative evidence to the contrary, and the trial judge essentially says, well, I believe her. I don't think that's a function of a judge. I believe it needs to go to a jury. I think once we take the function away from the jury of deciding who to believe, and I think we put forth some incredible evidence to suggest she's not telling the truth, or if she's telling...
What was that incredible evidence? Just remind me.
Sure. So on the issue of, I suppose, whether she's being forthright about her knowledge of the property and what's going on.
Yeah, what was your incredible evidence?
Sure. So she's there when this stuff happens. Additionally, there's
Stuff happens during the day when the nail salon is open, or is the nail salon an all-night nail salon?
No, it's not an all-night nail salon. And admittedly, if these crimes are happening after midnight, she's not there. She has people come into her nail salon who go to the club in the evening. They talk about it. More importantly, there was a human trafficking ring busted up at the property via a police raid. She says she knew nothing about it. She says that the
human trafficking ring leads to murder? Is that what you're suggesting?
I am not. I'm not suggesting that.
Sticking to the crimes that might relate somehow to the murder.
Well, we're talking about affirmative evidence that contradicts her veracity. And that's not necessarily related to the murder itself. We're just talking about, is this somebody we should believe when it comes to operation of a commercial property? And when her tenants are complaining to police about a human trafficking ring and they have to raid the property, and she says, no, that didn't happen. They're probably just racist, or they are in other people's businesses and they shouldn't. I think we can disbelieve her.
So,
I-
so on summary judgment on this question of law, you're suggesting that the judge defer summary judgment and put special questions to the jury to resolve whether she should have known?
I think when we do the inquiry of knew or should have known, when we get from duty to foreseeability and then prior crimes, and then do we believe her when she says, I didn't know about the prior crimes? When we get to that level and we're testing the veracity of the statements of the witnesses, yes, I believe we have to let that go to a jury. We can't take that function away.
Not believing her is not affirmative evidence that she knows. It's just so you need affirmative evidence.
I would say the affirmative evidence is she was there. She was a tenant at the building, combined with the additional affirmative evidence that she essentially is not doing anything at the property she is supposed to.
Doesn't there at least have to be, is there anywhere in the depositions about the, going back to Justice Wendland's point, anything in the depositions about the hours of the nail salon?
I believe there is, and I don't know the exact hours, but I think we can assume it's it closes in the early evening. I think it's 6 or 7 o'clock. I'm not going to suggest it was, midnight or 1 o'clock in the morning when most of the crimes take place. But like I said earlier, I think when you're talking about a rare instance of somebody buying a commercial property with a nightclub in it, the duty of inquiry follows the use of the property. And we see that all the time with landlords and property owners. You buy a property with a laundromat, you may do a phase 1 environmental test. There's all sorts of special situations.
Have to know about a shooting in 2009? Is that part of the duty?
I would say that if you inquired about maybe what happened during your own tenancy, you might find that out. Is it part of the duty? Negligent security law doesn't necessarily have a look-back period, at least that I found, where they said it's 10 years or 5 years. But we looked at 2014, and we cited 2005 and 2009. There was other murders, other shootings. But if you look at just during her tenancy, the period of time when she says, no, I didn't know anything, there's 3 people being shot outside the club. There's another a gun crime where they find bullet casings in the parking lot and they hear gunshots. And I believe there's even a third one, and there's other violent attacks where the police are called to the parking lot. So there's a tremendous amount of foreseeable, similar violent crimes. The question is just...
Is there a murder beside the one in 2005?
In the sense that somebody died, no. Other people were shot, and they thankfully lived.
Okay.
Any other questions?
Okay, thank you.
Thank you.
Attorney Powers.
Good morning, Your Honors. Please the court, Robert Powers on behalf of the appellee, Yu Fan. She is the sole owner of UTP Realty. Your Honor, nobody here disputes that the death at issue, the execution of Mr. Scott, was a tragedy. It was senseless. But the law cannot lay on a man or a woman's shoulder a more onerous burden than a judgment that they are responsible for causing the death of another person. And this is not a case, Your Honor, where that judgment ought to be rendered. The judge got it right below. The circumstances of this case were not created by my client. She did not control the circumstances under which Mr. Scott was murdered. She had no ability to prevent this targeted assassination. My client...
Are you arguing no duty, or are you arguing no causation, which goes to the jury?
Your Honor,
How is this a question of law? I mean, that's really the question here, is that there's no duty, given that there were these shootings, the murder, whatever, in the history of this property related to the nightclub that she's now inheriting. Why is there no duty to do something? I'm not sure what, but...
the general rule is there is no duty on anyone to prevent criminal acts by a third party.
Right, yeah, but we're
Except in
beyond
rare
that.
and
Yeah.
exceptional circumstances. Our argument is that on the facts of this case that there is no duty. But there's also an issue here, Your Honor, with regards to not necessarily causation, but proximate causation. And proximate causation as well,
But can we stick with the duty?
absolutely.
Yeah, because I'm wondering why there isn't a special relationship in light of the history of violence at the nightclub.
Your Honor, my client merely owned the property.
Yeah.
She was not operating the nightclub. As Judge Wilson noted below, this would be a solid case against the nightclub, but that's not the case at hand. The case at hand is against a property owner. Now, in this case, Ms. Fan operated a nail salon, so she's closer than an individual, a mere property owner, a commercial property owner who just leased the entire premises to somebody and no longer exercised control. But still, there is no evidence in the record that she exercised any control over the operation of city limits. And it's control and the ability to take,
But I thought the killing happened in the common areas.
Your Honor, if we look at the record, we see that Mr. Scott had left the premises. And there is a report in the record where one of the responding officers noticed that Mr. Scott's body was lying about 7 feet from the front door. The space between, this front door opened up onto a access way to to a parking lot, to other commercial businesses. There was a very small.
But see, now you're getting into factual disputes. I'm not sure how this is helpful for you on summary judgment. Let's assume that the murder happened in the common area. What's your client's duty in light of the history of violence at the property?
In the common area, Your Honor, I'd still say that there is no duty, because the duty under the case law, okay, is not only the foreseeability, okay, but the ability with that knowledge to be able to take preventative steps, something that might have stopped what happened from happening.
And you're saying that's part of the definition of duty?
Absolutely, Your Honor. Your prior
So
cases.
not just foreseeability, but the ability to prevent this particular crime?
I think the
I'm not
Whitaker
suggesting
case?
it's not, I'm just asking.
I think that the cases decided by this court and by the appeals court have always said that you need to look to the totality of the circumstances. It's not just a question of listing prior crimes. It's not sufficient to just list crimes that go back 10 years that have nothing to do with an individual. The question is, in the totality of the circumstances, was it foreseeable to the defendant? And was the defendant, with that understanding, in a position to take reasonable preventative steps?
How much do we don't, in one sense, there's significant case law, but in another sense, the foreseeability and knew or should have known, and the duty to prevent violence from a third person, that the context in which we've discussed that has been in the residential context. The Hotel Lennox case that has been referenced, not necessarily a good case for you, but that's not about duty. That's about causation. Duty wasn't contested in that case. So we don't really have any help from that Hotel Lennox case. So why is it that we should carry over our law from residential to commercial in this context, as it relates to preventing harm from third persons?
I don't know, Your Honor, that there is a distinction between residential and commercial when it comes to the prior cases. For instance, in the Louisi versus Foodmaster case, you had the operator of the store and you had the landlord who leased the property to the operator of the store. And in that case there, a patron of the store was stabbed. Another patron came in, they took a knife from a display, and they, unprovoked, stabbed another patron. The case against the store was not ripe for summary judgment. The decision was that needed to go to the jury, because the question of whether or not they had displayed the knives in a fashion that created that opportunity for what happened, That's something that goes to the jury. But with regards to the landlord, the issue was decided on duty. The landlord, the commercial landlord, did not have a duty in those circumstances. The general rule doesn't say it's the general rule that applies this way to commercial and this way to residential properties. The general rule is that you are not responsible for the the criminal conduct of a third party, okay, except in rare, exceptional circumstances. And you look at the totality of the circumstances facing the defendant to determine the duty.
Well, you also have the benefit of the appeals court case, Bellazar, where we talk about, okay, if you have a lease, that further attenuates your duty, right? So here you have a lease, the nightclub owner is responsible for policing and security in its own facility. That helps you. We'd be pushing the law a lot if we hold your client, because we'd not only be creating a duty of, you know, the person operating the facility, the nightclub, but we'd be extending it to a landlord who's given out a lease. Any cases like that? I mean, I think that's your best argument, right?
It is a solid argument, Justice Kafka.
Just a coincidence that he wrote that.
My apologies then, I was unaware of it. But it is true that in a myriad of areas in the law that you can look to a contract to determine, you know, it bears on the issue of duty. And, you know, in this case here, when you've got a commercial landlord who cedes control to the tenant, yes, that is one of the factors that ought to be considered in the totality of the circumstances in determining whether or not.
And I mean, I guess to Justice Wendland's question though, which is the harder one, right? Okay, so it happens in the common area, but it's not like there's a defect in the common area or any security problem in the common area that causes the problem, right? It's just, you know, if there's a defect, it's the security within the building, right? It's within the nightclub. Do they have enough cops in there, right?
Exactly, Your Honor. There's nothing, you know, the fact that this murder happened within several feet of the front door does not, you know.
And it's not like they threw him out the door, right? They don't take two guys fighting and throw them out of the bar and say, go settle it outside. They don't do that here, right? Or do they?
No, Your Honor, there is absolutely no evidence of any interaction.
That might be a little different, right?
It would be, but this case needs to be decided on those facts. And the facts in this case, there was no interaction, okay, between Drake Scott and Mr. Wright.
But what the plaintiff is saying is, if you look at the previous incidents, there's lots of fights in the club that spill out into the parking lot. And that if you have police officers in uniform there, that's going to prevent, or at least make it less likely that you're going to have a shooting steps from the nightclub. So so their view is, well, look, if you did any due diligence here, you'd see all these fights that spilled out into the neighborhood, including even into the parking lot, including one while you've been landlord. And so you should know that having some sort of security there and police officers there is important for security. In fact, it's your duty to do so.
Those are not the facts of this case, Your Honor. I mean, you say lots, yet we go back 10 years to the murder, okay? And in the 10 years before,
Well, February
we've got 10 to
23rd,
12
parking lot fight. March 7th, 2004, parking lot fight. June 6th, 2004, fight in club spills into the parking lot. July 25th, fight in parking lot.
all of which predate my
No, I'm
client's
just
ownership.
saying, this is not something that's rare, something that keeps on happening. As a matter of fact, the Randolph Licensing Board's really concerned about it, as is the police department.
Exactly, Your Honor, except that in this record, there is no evidence that the town of Randolph or the police department went to my client and said anything about this. They went to city limits.
Is there anything in the lease about security?
The lease cedes control and operations and obligates city limits to operate, conduct their business in accordance with the law. There is nothing in the lease specifically with regards to providing a specific type or amount of security or to insure against the loss. There's nothing of the like. In that regards, Your Honor, it's a rather simple lease. But, you know, it's also important here, Your Honor, to understand that when we're talking about, well, a police officer outside of the front door might have made a difference here, that the police were outside the front door. Detective Tewitt, who was inside the premises, when he had heard, about the possibility of trouble brewing afterwards, had put in a phone call. And he testified when he stepped out of the front door, that within 5 to 10 seconds, Mr. Wright was being chased by police. They were right outside the door, and yet, and there was a witness.
That's not the point, though. The point is that if the patrons know the police are there, it's not that some person who was frequenting the club told an off-duty police officer who made a call. I'm not saying they're right, but you have to address the argument, which is you've got all of these fights spilling into the parking lot. You've got shootings that have happened in the parking lot. And the question that arises in that circumstance, it doesn't matter simply whether the landlord knows. You also have to analyze under our case law whether they should have known, whether they should have had a police detail there when it's not every single strip mall, but when there's an active nightclub.
Your Honor, I think for the reasons outlined in the amicus briefs, for this court to expand a duty on an individual property owner like my client to pay for a police detail to protect a business who she's just simply leased the property to, and they're responsible for their operations, and no evidence that she knew about what was going on at 12 o'clock or 1 o'clock in the morning. No evidence that the town ever spoke to her. That would be unfair. As I said, at the outset, Your Honor,
Couldn't she pass along the costs to the tenant through what's called rent?
Your Honor, certainly, if you've got a sophisticated commercial entity, that's probably one of the things that they're going to talk about. But when you're talking about a woman who immigrated here from Vietnam.
And is that how we define the duty based on the commercial landowner?
I am not suggesting that, Your Honor. What I'm suggesting is that the rule has to apply across the board, and the rule is the totality of the circumstances. And the judge below, looking at the totality of the circumstances here, made a judgment. That's the province of the court, the sole province of the court to determine. And in this case here, Judge Wilson determined that there was no duty. On the facts of this case, that was the correct decision, and I would urge the court to affirm the decision in favor of my client. Thank you.
Thank you.